The darkness continues.
Peace, folk. Welcome back to another edition of the Prophet of Thought series right here on the old T.P.O.T YouTube page. I'm your host, X, of course, but you knew that already. That's why your black asses are here. Well, I'm back with another. And today we are back with another one of these I guess these are arraignments that I'm looking at today. You know, I only bring these to y'all when I see some things that stick out. And today's subject is criminal trespassing and being criminally evicted. And the reason why I'm titling it this is because a lot of these cases that are in here today are for criminal trespass. And I mean, there's a few in here that's for battery, but I think the overwhelming majority of them are for criminal trespassing. And the ones that are about battery, you're going to see how people have been pretty much criminally evicted out of their house based on their charges. Now, let me say this before we start. All the people that you see here today are presumed innocent until the state can prove them guilty. They are assumed innocent until the state can prove them guilty. So let me just bring you up to speed on the statutes. Far as the criminal trespass, it says here, according to Georgia Code 516 of the criminal law, it says a person commits the offense of criminal trespass when he or she intentionally damages any property of another without consent of that other person, and the damage thereto is $500 or less, or knowingly and maliciously interferes with the possession or use of real property of another person without consent of that person. A person also commits the offense of criminal trespass when he or she knowingly and without authority enters upon, on the land or premises of another person, or in any part of any vehicle, railroad car, aircraft, or watercraft of another person for an unlawful purpose. Person enters upon the land or premises of another person, or into any part of any vehicle, railroad car, aircraft, or watercraft of another person after receiving, prior to such entry, notice from the owner, rightful occupant, or upon identification and authorized representative of the owner or rightful occupant that such entry is forbidden, or remains upon the land or premises of another person, or within the vehicle, railroad car, aircraft, or watercraft of another person after receiving notice from the owner, rightful occupant, or upon proper identification of an authorized representative of the owner or rightful occupant to depart. It says a person who commits the offense of criminal trespass shall be guilty of a misdemeanor. So criminal trespass is a misdemeanor. I'm also going to tell y'all about battery. Let me explain to y'all what that is. It says a person commits the offense of battery when he or she intentionally causes substantial physical harm or visible bodily harm to another. As used in this code section, the term visible bodily harm means bodily harm capable of being perceived by a person other than the victim, and may include, but is not limited to, substantially blackened eyes, substantially swollen lips, or other facial or body parts, or substantial bruises to body parts, except as provided in subsections D through L of this code section. A person who commits the offense of battery is guilty of a misdemeanor. So we're talking about misdemeanor charges here, good folk. All right, let us be clear. And I say again, all these people that you see here are presumed innocent until the state can prove them guilty. All right? All right. So let's get at it.
So we will begin with courtroom 2. Who do we have?
Your Honor, we have position number 2, Mr. Christopher Bass, and he also has his mother in the gallery.
All right, thank you.
And by the way, this judge right here, and I know I brought y'all this judge before. I believe the judge's name is the Honorable Jesse Law, I believe it is. This judge is no nonsense. This judge doesn't play no games. This judge is hard, but this judge is fair. That's one thing I like about this judge, because I've watched this judge many, many times. I've watched this courtroom many, many times. This judge is hard, but this judge is also fair. Given the cases that come before this courtroom, it's some stuff that come in here, boy, that make you laugh, but it's also some stuff that make you cry. But we continue.
This is Mr. Christopher Bass, accused of loitering and prowling at 2111 Howell Mill Road in Atlanta, Georgia. Mr. Bass, you've been advised of your right to remain silent, and your attorney is presently Miss St. Lex?
That's correct, Judge.
All right. All right. And Ms. Harrison, any priors, please?
Prior, Judge. He is recommended for you, JR.
All right. And Ms. Anderson, what's the state's recommendation?
Good afternoon, Your Honor. The state recommends a $2,000 surety bond, no further contact with the victim, Catherine Gentry, Gentry, and a stay away from 2111 Howell Mill Road. Yesterday at 11 a.m., Mr. Bass.
I've read the warrant. I'm actually
great.
more interested in listening to his mother, if she'd like to testify.
Now, this dude is in here with his mother. Now, look at this dude. This dude looked like he could be, I don't know, probably about 35, 40. Why is his mama in court with him? For what reason? What is mom gonna come up there and say at an arraignment? What's she gonna do? Come in there and tell the judge how good a boy he is and how he didn't do anything? What? What is mom gonna do? Come in there and talk about things that happened when he was a kid? I mean, come on, man. But we continue.
Same. Thank you, Your Honor.
Thank you, Ms. Anderson.
Your Honor, I don't have my key.
Okay. If you could just inquire of what's her name and what's her address.
How the hell the CO don't got the key to the damn door? Because if you look in your top left-hand corner of your screen, right, you see these people sitting back here, right? Now, behind these people, behind the people sitting in this courtroom gallery, I believe it is, it's the jailhouse courtroom gallery. Behind that is a glass wall. And if you look in the top left-hand corner, I believe that's his mother sitting back there. Now, to come inside of there, the corrections officer has to let you in there. But you heard what he just said. He don't got the damn key. Now, how don't the jailer have the keys to the jail? Oh, God. We continue.
Address.
Okay. What's your name and your address?
He's literally listening through the metal door as she speaks. Jeez.
It's Ms. Bass, and I believe it's 517?
5170.
5170 Lincoln Drive, Fairburn, Georgia.
All right, that's a little ways away from Howell Mill Road. Mr. Bass, your bond is going to be set at $2,500. That's going to be a signature bond through pretrial services.
Now, remember I told y'all before the difference between a surety bond and a signature bond, because If you have a surety bond, that's something considered, it's called a good bond, meaning that whatever your bond is, if you pay a bondsman 10% of that, they will get you out of jail, right? But they do something now, especially in this courtroom, they do something called a signature bond, where you can literally walk up, you sign your name in the jail, and you can get out. Now, what that signature bond means is that whatever it is, say it's $2,000, $3,000, which are popular numbers in this courtroom, if your signature bond is $3,000, you walk in there, you sign your name, you get out. If you get in more trouble, or you fail to appear to one of your court dates, they issue a warrant for your arrest, anything like that, when you come back to court, now that signature bond becomes a surety bond or a good bond, because now you have to pay that $3,000 that you signed for when you got out before. So basically, when you sign your name, what you're saying is, I'm signing my name, I'm leaving the jailhouse, but if I screw up and I come back, I have literally signed saying that now my bond is $3,000. And now you got to go to a bondsman and pay, $300, and the bondsman will get you out. So those are the differences between those two bonds. But we continue.
You are to stay 200 yards away from the entire location known as 2111 Howell Mill Road in Atlanta, Georgia. You are to have no further contact with Catherine Gentry. And once you're out on pretrial, you're to report to pretrial once a month. You are to update the court with your new address or your current address so that you will not miss out on your future court summons. Ms. Saintflex, does the Public Defender's Office represent him from this point onwards?
Yes, Your Honor.
All right. Mr. Bass, I highly recommend that you consult with the Public Defender's Office as to what your next option is. Thank you.
I don't have my key to let you in to talk to the judge. His mother wants to say something. I guess we can.
She has nothing to say to me. She can speak with the Public Defender's Office.
You heard the judge. The judge said she has nothing to say to me. I mean, there's nothing to say. The judge is letting him out, signature bond. I mean, he's going to walk out of there today. So there's nothing to talk about. I mean, I don't get it. These people be in this courtroom, and I don't know why we do this as black folks. We always want to talk when we should be shutting the hell up. There's nothing to say. He's getting out, your old mama, you. So why do you want to come in there and talk to the judge? You can't get in there anyway because the damn CO don't even have the key. All right? The mama's boy's getting out. Just leave it at that and shut your ass up, your old mama, you. But we continue.
It's all with the Victim Advocate's Office. Does she want contact with her son?
Yes. She said yes.
Okay, then there's nothing else to be said. We can move on to the next case.
Okay. Next.
Like I said, look at this dude. This dude look like he's 35, 40 years old. He in court with his damn mama, and she trying to come in there and speak on his damn behalf. She's trying to come in there and speak on his damn behalf, and he's getting out. There's nothing to say, mama. Shut up and pick him up in front of the jail. We continue. Fair use, Negroes. Fair use.
We're going to go to position number 3, Ms. Sabrina Buford.
Ms. Buford's case number is 22 CR 007743G. She has been accused of battery, domestic violence from November 11, 2022.
Here we go with the battery that we discussed at the top of this presentation. But we continue.
Ms. Buford, you've been advised of your right to remain silent, and your attorney is Ms. Saintflex. Any priors, Ms. Harrison?
5 cycles, Judge. Last arrest was March of 2009 for possession of cocaine with intent to distribute.
Possession of cocaine with intent to distribute. She used to be a drug dealer. put on the Ferrilla. Now she's a born killer. We continue. Fair use.
No disposition listed on that arrest. Record does indicate a 2007 battery, simple battery, family violence, and that charge was dismissed.
All right, thank you. Ms. Anderson, I'm familiar with the warrant. Is it Ms. Anderson right now?
Yes, Your Honor.
Okay, sorry. What's the recommendation in terms of contact and the bond?
$5,000 surety bond, no drugs, driving, alcohol, or weapons, and no contact with the victim, Aranmila Lay, Aaronnila Lay, who is the defendant's daughter.
And do you know if that person is of the age of majority?
I don't, Your Honor. We definitely attempted to contact Ms. Lay multiple times today, but I don't know her age.
All right, thank you. Ms. St. Flex?
Yes, Your Honor. It's my understanding that she's 17 years old, but she's going to be living with her father, and that previously she was sometimes living with her other sister, who is 32 years old. I have spoken with Ms. Buford about no contact, so she has no issue with that. Because that address is Ms. Buford's address and the daughter is not going to be there, we would just ask that it stays as a no further contact. Her name is on the lease.
How do you know that there's...
Now you heard that, right? This woman that's sitting here in the jailhouse blues right now. This is her house, right? Her name is on the lease. But listen to what she's going to get told by the judge. Remember, the title of the stream. The title. Criminal trespass. Criminally evicted. Let's continue. Fair use, Negroes. Fair use.
that she's not living there?
From my understanding, speaking with Miss Buford, she said her daughter does not live there. She went to pick her up from the hospital when this alleged incident happened, but she's been living back and forth with her father as well as her sister, who's 32 years old, from my understanding. Mrs. Buford also just informed me that she's not working right now. She's had some diagnoses that's caused her to be unable to work. And so she's not going to be able to afford $5,000 surety bond. As far as the bond, we're asking for a SOB or I don't know if she qualifies for pretrial, but we're requesting an SOB bond. I think the last incident that was spoken about was a charge that was in 2009. But as far as the driving, we would object to any restrictions on her driving. I think that was a recommendation. I think this only has to do with an incident with her daughter. And so if there's anything for driving that's restricted, we would just request that's allowed to go through GDS.
Bond is going to be set at $5,000. It's going to be a signature bond through pretrial services. She will be released on the signature bond. She's to have no further contact with, I'm so sorry, I would make sure I don't mispronounce his name, Aranmila Lay. And she may return to the Sandtown Road location one time only with a police officer. She may return into the property if it's verified by the police officer that Aranmila does not live there.
Now you heard that, right? She's just been told by the judge that she cannot return to her own damn house except to retrieve her belongings. Now that's her house. Her name's on the lease, but she cannot return there because this is a quote unquote familial domestic incident and that person lives there too. But we continue.
If Aranmila is still residing in the property, then she has to stay away from that location until Miss Aranmila Lay vacates the property. She is to have not consume any alcohol, no drugs, and not possess any weapons or any firearms. While she is out on a signature bond through pretrial, she will, if she needs to live in a different location until Miss Lay vacates the property, then Miss Buford will have to update us with her new address. I'll also require her to do an 8-week anger management program, and she may begin those classes within 60 days of being released from the jail.
An 8-week anger management program before you're even convicted. This is based off of an accusation of something happening, not a conviction. But we continue. Fair use, Negroes, fair use.
And she will report to pretrial when she begins those classes, and it would have to be at her expense. So please understand, Ms. Buford, your first visit back to your home once you're released on your pretrial bond is with a police officer.
Your first visit back to your home is with the police officer.
And the police officer will verify whether your daughter is still living there. If your daughter is not living there, you may return to the property. But if your daughter is still living there, you can only go and retrieve your belongings, but you must stay away from that location until she vacates the property. That is, that she goes to live with her older sister or goes and lives with her father. Our next court date will be sent to Ms. Buford's address, either at the Sandtown Road location or the new address that she provides.
Now, is that justice? Does that make sense to you, good folk? You get into a confrontation with somebody, whether it's your girlfriend, your boyfriend, your son, your daughter, it's your house. But you're being told by a judge that you cannot return to your own house. So what does that mean? Does that mean never get into a confrontation with somebody at your house? Because it seems like to me, if you get arrested at your house for doing something to somebody, you are now not allowed to come back to your own house, especially if that person lives there too. So that person can literally just live in your house. Like I said, whether it's your boyfriend, girlfriend, mother, father, son, daughter, whoever, friend, they can just live in your house and you can't come back there until they decide to move. So I guess if they wanted to stay there for the next 6 months, you'd have to continue to pay the mortgage, keep the lights on, keep the water on, keep the gas on, while they just live there. Because legally, you can't even return to your own residence. Yeah. Fair use, Negroes. Fair use.
I have Mr. Hines, position 6. I understand there is private counsel in the courtroom. Are we ready to address that?
We can, Your Honor. I can bring them up.
If they're ready.
So you can speak it if you want. Say something.
Sorry, Mr. Jordan? Sorry, Mr. Jordan.
Speak. I was just asking the attorney to say something in the mic, Judge.
Good morning, Judge. Andrew Hughes on behalf of Mr. Hines.
Brother got him a lawyer. He said, man, I ain't trying to mess around with this damn public defender. I see too many people going to jail. But we continue. Fair use, Negroes. Fair use.
All right. And could you repeat your name again, please?
Andrew Hughes, Hughes.
Thank you. All right. Mr. Terrence Hines is in courtroom 2, case number 22 CR 007748J. This is a vehicular situation that occurred in the second degree on November 11th, 2022. In addition to that charge, Mr. Hines is also accused of failure to yield the right-of-way to a pedestrian, failure to exercise due care with the pedestrian. Those are the 2 charges. Mr. Hughes, are you familiar with the 2 charges brought against him?
Yes, Your Honor.
Okay. And this allegedly occurred on November 11, 2022. You have the new accusation number, yes?
No, I don't, Your Honor. Could you repeat that for me, please?
Sure. 22 CR 007748J. Mr. Hines has been advised of his right to remain silent, and you are his attorney, Andrew Hughes. Ms. Ann Harrison, do you have Mr. Hines' GCIC or
Yes,
motor vehicle
yes,
record?
Judge, no prior history.
Okay. Miss,
Well, the brother don't have any prior history, so he's looking good. Because one thing I've noticed about this judge, if you don't have any real serious prior history, she usually takes that into consideration and she don't try to slam you as hard. But we continue.
Anderson, have you and Mr. Hughes discussed bond?
No, I haven't spoken to Mr. Hughes yet, though it is a pleasure to see you today, Mr. Hughes.
Pleasure is mine.
All right, I've read the warrant. I understand the circumstances of this case, and this is a misdemeanor charge. Would you and Mr. Hughes like to discuss bond, or do you want me just to go through the normal process?
I think it's okay to go through the normal process, Your Honor. The state recommends a $10,000 surety bond and no driving.
All right. And Mr. Hughes?
Your Honor, good morning and good afternoon, rather, and thank you for your time. I'm here this afternoon and we're asking for a signature bond. Despite that, I assure you that Mr. Hines appreciates and understands the significance of the allegations that have been made against him. I will submit to the court that he is not a flight risk. He has been a resident of Georgia for more than 26 years, with his most current address at 3702 Rosebud Park Drive in Snellville, Georgia. He's been a resident there for more than 15 years. He is currently married and his wife is here to support him this afternoon. They've been married for more than 26 years as well. Mr. Hines also has the full support of his employer as well. He's been employed for nearly 9 years with Advanced Republic Disposal Services. He works there as a commercial driver. I will submit to the court that he poses no threat or danger to the community. As the assistant solicitor mentioned, he does not have any criminal history at all. I've reviewed several years of his driving history and only discovered that he was convicted of a failure to obey a traffic control device back in 2018, but it's not had any violations before or since then. Your Honor, I would further submit that he is not a risk to the community. Is not at risk of committing any further felonies. In addition to that, he does belong to a church near the Georgia Stone Mountain area.
Now, the lawyer goes into this. He had me until he went into this stuff. You know, he started talking about what church he went to and, you know, all this philanthropic stuff and, you know, all this kind of stuff. Because this is what your lawyer does, right? Especially in your initial appearance, you know, they say, well, you know, I've told y'all this many, many times. The lawyer comes in and he says, well, this person's been living in the area for X amount of years. This person has his mother here, his son here, his dog here, his bird here, his cat here. He's a member of the community. You know, he feeds the homeless. He feeds the pigeons in the park. You know, they're just going through this whole soliloquy. They're going through all this stuff that doesn't mean anything. All right? Because look at the judge's face where I freeze to that. The judge doesn't care about any of this stuff. When he was talking about the other stuff, whether or not he was a flight risk, whether or not he was a continued risk to the community, his likelihood of reoffending, that's the stuff that interests the judge. The judge don't care what church you go to. The judge don't care where you play golf. The judge don't care that you go to the homeless shelter and hand out jackets, blankets, and socks. The judge does not care. They don't. I repeat, they don't. But your lawyer goes into it anyway, this whole spiel, and it means nothing. But we continue. Fair use, Negroes. Fair use.
Where he's been an active member for several years. He's also involved in several philanthropic efforts within the city of Atlanta. As a part of those philanthropic efforts, that includes making donations during the holiday seasons to help feed the less fortunate.
He hands out turkeys, on the corner every Thanksgiving. But we continue.
I will submit to the court that Mr. Hans is.
You see the judge ain't even paying attention. The judge is not paying attention.
A great candidate for a signature bond, again, despite the serious and awful circumstances that have landed him where he is.
Anything else?
I would just also submit that he has not had any prior mental health concerns or any allegations or concerns with substance or alcohol abuse as well.
Now, because the Solicitor General, and the Solicitor General is that person you see in your top right-hand corner. I know usually in these cases, the bond, even if they want to hit you with a somewhat high bond, it's usually about $5,000, somewhere between $3,000 and $5,000. They ask for 10. So I'm assuming on these misdemeanors, there are some mitigating circumstances, like something serious happened, adjacent to these misdemeanors, because they don't usually ask for a bond that high. I know this is some type of traffic case, so I don't know, maybe the brother ran somebody over, hit somebody, I don't know. They're not really reading the quote-unquote charges today. I noticed that. They're very, they're very covert with how they're explaining the charges. They just basically, this is more like a bond hearing more than anything else. I don't even think it's so much of a arraignment. It's more of like a bond hearing. But I do believe these are initial appearances. And the brother's bond, the Solicitor General asked for $10,000. So whatever he did in the commission of these misdemeanors probably was serious. There was some type of serious results. So there is that. But we continue.
It is a tragic incident, giving rise to these charges. On the first charge is going to be a $1,500 surety bond. On the remaining charges is going to be an $8,500 signature bond through the pretrial services.
Now, the judge went along with the Solicitor General, $10,000. But notice what she said. $8,500 of it is a signature. Only $1,500 of it is a surety. So basically, this brother's going to pay $150 and walk out of there, even though his bond is $10,000. Now, I know that doesn't make sense to y'all, but listen to what's happening here. This is something called a split bond. One part surety, one part signature. His signature part is $8,500, so he's just going to sign his name, right? The surety part is $1,500. On that, he's going to have to pay $150 to a bondsman, and they're going to put up the $1,500 bond for him, and he's going to walk out of there for $150, even though his bond total is $10,000. All right, we continue. Fair use, Negroes. Fair use.
His total bond is a $10,000 split bond. I understand that he does have the support of his employer, but at the present time, I need him to not be operating any motor vehicle for the next 60 days.
Wait, hold on.
Ms. Harrison?
Wait 1 second. Yes, Judge.
Okay, what's the ratchet noise in the background? See, that's another thing that happens, because this is in Fulton County, Georgia. So most of the people that's part of the legal system are a bunch of black broads. You see the court reporter, you see the public defender, the solicitor general, the stenographer. They all just a bunch of black broads. The only person that's white is the judge. So you be hearing kids in the background, because a lot of them, I think they do this from home. So you hear babies crying. Sometimes you hear some ratchet Nicki Minaj music come on, and all kinds of foolishness takes place. Because wherever there's black broads, there is foolishness. Even if they're lawyers, even if they're the district attorney, even if they're the public defender, there's some foolishness involved. But we continue.
Okay, can we mute screen, please? Okay, thank you. I just want to be sure. All right, as I was saying, it's a $10,000 split bond. He is not to operate any motor vehicles for the next 60 days. So I'm not sure how his employer can accommodate him in that, but I'm sure they could. And while he's out on 60 days, I need him to take a defensive driving class. And I have a feeling this will be more up to the insurance companies than really the courts.
Understood.
All right. Thank
Your
you.
Honor, would you, I'm sorry, Your Honor, would you please restate that split bond?
$1,500 for the for count one and $8,500 for count two.
Thank you, Your Honor.
10,000 split bond. I just want to be sure, and I want to check his address. Do we have his current address?
If not, I do have a current
I just need the
address.
street name.
Rosebud Park Drive.
All right. So, Mr. Hughes, that's the address we have. We will send him. His next court date is December 1st. No, is it December 1st?
Yes, it's December 1st.
Okay, his next court date is December 1st. That's a state all-purpose calendar. Of course, if he makes bond, then his court date will be amended, and he will get notice in the mail as to the next court date. If you decide to file a waiver of arraignment and so forth, you may do so anytime from today. Please go ahead and file your entry of appearance as well.
Well, Your Honor, just for a moment of clarification, that $1,500 on count one, is that a good bond?
That's a good bond, and the remainder is a signature bond through pretrial.
Understood. Thank you, Your Honor. This is
All
the
right.
business that I have with the court this afternoon. May I be excused?
Yes, sir. Thank you, Mr. Hughes.
Thank you.
Courtroom 2, next case, please.
Next, Your Honor, we have position number 4, Ms. Covington.
This is State versus Natasha. I'm sorry, it's Matasha. I've got M. Matasha Covington, accused of criminal trespass causing damage to property.
Another criminal trespass. We continue.
And theft by taking in case number 22 CR 007745Y. This is incident from October 7th, 2022 at the Red Rice Restaurant. Ms. Covington, you've been advised of your right to remain silent, and your attorney is Ms. St. Flex. Ms. St. Flex, is this a confirmed representation?
No, Your Honor. Ms. Covington is going to hire service.
All right. So, Ms. Covington, you are represented by the Public Defender's Office only for today's proceeding. But after today, you're going to have to hire your own private attorney.
Okay.
All right. Ms. Harrison, any priors, please?
No prior, Judge.
All right. Thank you. And Ms. Anderson.
Good afternoon, Judge. The state is asking for a $2,000 surety bond, no contact with Miss Pershetta Mack, PERSHETTA who is the owner of the Red Rice Restaurant, and to stay away from the Red Rice Restaurant located at 1401 Moreland Avenue Southeast.
What'd she do? Steal some food? Did she come into a restaurant that she was? Because basically, criminal trespassing is what, right? When you get down to it. I know I read all the statute and all the gobbledygook that goes along with it. But basically, what criminal trespassing is being somewhere where you're not supposed to be. Or being somewhere where someone has told you they don't want you to be there and you have returned. I mean, that's the meat and potatoes of that charge for the most part. And it's a relatively minor charge. The most you can do on it is 120 days. And I think the fine, the most the fine is like, I don't know, like $1,000 or something like that. So it's a relatively minor charge, but you see a lot of those charges come through this particular courthouse. We're gonna zoom past this one, folks, because this one is boring. Let me see what else we got. What else we got? Okay, let's stop here. We had a good one here. Here we go. Fair use, Negroes. Fair use.
And next we have position number 11, Mr. Reynolds.
All right.
And he has his sister in the gallery.
All right. This is Nikua Reynolds, 22 CR.
Nikua. And of course, you always see some of the dumbest names you've ever seen in your life come through here. The dumbest names. These people have been named for failure. Can you imagine? Can you imagine for a second? Let's digress for a second, people. Can you imagine working in HR and you see a job application and it says Nikua on it? What's the likelihood of you just taking that application and putting it in the paper shredder? Well, what's the likelihood of it? Let me know. But we continue.
007736C.
It's not Quay Reynolds.
Sorry?
Not Quay Reynolds.
Oh, it's not Nikua. It's Nyquay. Nyquay is his name. I don't know about y'all, but I refused to let my kid's mother name my kid something stupid. Now, she probably would have if I wasn't around, because that's kind of what it is, right? You don't run into too many children that got fathers in their lives and they got these stupid ass names like Nyquay or J. Marquavius or Trailer Marcus or Devontion or something stupid like that, right? That's usually some old baby mama naming them some made up dumb shit and think it means something. What you've done is named this child for failure. That's what you've done. You've put failure. You might as well had named him Failure Jenkins. You might as well just had named him that, because you see where he sits, right? You see where Mr. Nyquay sits, right? But we continue. Fair use, Negroes. Fair use.
Nyquay Reynolds, okay? And Mr. Reynolds is accused of battery causing substantial physical harm and cruelty in the third degree.
Another battery. Remember, criminal trespass and battery. Those are most of the charges you're going to see here. But we continue. Fair use, Negroes. Fair use.
All right. From November 18th, 2021. Mr. Reynolds, you've been advised of your right to remain silent, and your attorney is going to be Ms. Bianca Thomas. Ms. Thomas, is this a confirmed representation?
It is, Your Honor.
All right. And let's see, Ms. Harrison, any priors on Mr. Reynolds?
3 cycles. Last arrest was January of 2012. Theft by taking in Atlanta, Georgia. No disposition listed on that arrest. Record does not indicate any convictions, Judge.
All right. Thank you. And Ms. Salette.
Yes, Your Honor. I know the warrant.
And why does the Solicitor General's camera always look like that? If y'all look at these things that I show y'all, notice, look how everybody's cameras look, right? Everybody's camera is pretty clear, you know. They're at least 1080. I don't know what the Solicitor General films with. It looks like they're filming with like a 16 millimeter. And this is the Solicitor General of Fulton County. Can they not afford a good camera? Can they not afford a decent green screen setup? Everybody's camera looks better than the Solicitor General's camera. Even the public defender has a decent camera, but the Solicitor General office does not. I can't grasp it. It always looks like this. They look like a video game characters or something. It's ridiculous, man. It's the most ridiculous thing. Somebody need to tell them that they're doing a bad job of representing the Solicitor General's office with this crappy quality of film while they sitting here trying to keep somebody in jail. Upgrade your damn camera. But we continue.
Only discusses the battery against Daquania Ellison.
Daquania. I ask again, if you're sitting in the HR department and you see an application with Daquania on it, how likely are you to put it in the paper shredder? But we continue.
But the report that we have also mentions that he battered his children's mother as well on that day, that Miss Danielle. We just wanted to add that in for the record as well. The state's recommendation at this time is
Now, why didn't the public defender object to that? Because, see, he's not in there for that case. All right? That's what I don't understand about these so-called public defenders, but I guess that's why they work for the public defender's office, right? She should have objected to that because he's not in there on that case. So the Solicitor General knows better to be mentioning that, and the judge let it slide. He's not there for that. He's not there for that. But it was allowed to slide anyway. But we continue.
$7,500 surety bond, no contact with the victims. Daquania Ellison, that's DAQWANNIA Ellison, ELLISON.
Because he's there for battering Daquania, not that other person, his kid's mother. He's not there for that. Miss Badass camera resolution, Solicitor General. But we continue.
There's also a cruelty charge where the victim mentioned in the warrant that minor child was present during the incident. We would also ask for a stay away from that minor child as well. The initials are LB. And a stay away from that incident location, which is 50 Mount Zion, apartment 5 in Atlanta, Georgia. No alcohol, drugs, or weapons while out on bond.
All right. Thank you. Ms. Thomas?
Thank you, Your Honor. I spoke with Mr. Reynolds. He is strongly denying these allegations. He is 28 years of age. He's been a Georgia resident all of his life. He does have family here. He is the father, of 4 children, Your Honor. He completed the 12th grade. Mr. Reynolds was also employed at Chops Lobster Bar. He's been working there for the past 8 years. He works there as a cook, Your Honor. We would be asking for a signature bond. I understand that Mr. Reynolds does have a separate case that might have him tied up. However, Mr. Reynolds did express that due to his situation currently, he's not sure whether or not he's still going to be employed. And given that he does financially provide for his children, he's not going to be able to make a high surety bond. So we are asking for a signature bond, or if the court is not inclined, a bond no more than $2,000.
All right.
I'm sorry, Judge. This defendant also appeared in first appearance?
Yes, I noticed that too.
Okay.
What bond did he get in that case?
$20,500.
Okay.
20,000. Man, he had some serious charges somewhere else. But we continue.
Officer Norris, did his family, one of them want to say something, or shall I proceed? No, you look in front. Reynolds, you look in front.
No, you look in front, Negro. But what is his family going to come in there and say at this point? He's got a $20,500 bond somewhere else, right? So he needs what, $2,050 to get out on that bond. So what is the person going to come in there and say? I assume now the CO finally has found the keys, or maybe one of the other COs gave him the key. So now he can let people in and let them talk and say some stuff that's totally irrelevant to him getting out. But we continue.
You don't turn around.
I'm sorry.
Only one person.
Can I touch you? You can't touch me.
All right, good afternoon. May I know with whom I'm speaking?
I'm his big sister.
I'm his big sister. What? Why not just come in there and say you're his sister? You're his big sister. This dude is 28. He's 28 years old. His big sister?
Demetra Ellison?
No, Denitra Dawson.
It's a little muffled, so you have to speak louder.
Oh, Denitra Dawson?
Donaldson, okay.
No, Dawson, Dawson.
Dawson. And how do you know Nikua Reynolds?
Not quite. We have the same dad.
We have the same dad. Of course you do. But not the same mom.
Okay. And do you share the same property at Mount Zion Road?
No, ma'am.
All right. What would you?
They don't even live at that property anymore.
Okay. And what would you like to tell me?
I was just gonna ask what his attorney is for a signature bond, because right now we don't have any money like that, and I just got back on my job, so I can't even help him if I try.
As if the judge gives a damn whether or not you can afford to bail this dude out. Like the judge cares. Oh, I just got back on my job, so, I couldn't help him if I tried. So why is your black ass there talking? You're no help to him. None. Just need to talk. Just need to talk. Aye. But we continue. Fair use, Negroes. Fair use.
All right, and you do understand that he has another open case with more serious charges?
Yes, ma'am.
All right. Do you know Daquania Ellison?
Yes, ma'am.
All right.
I know her.
I'm sorry?
I know of her.
Okay. All right. Thank you.
Mm-hmm.
Thank you. Get your ass out of here.
On the battery substantial physical harm, I'm sorry, Ms. Thomas, did you have anything else to add?
Nothing, Your Honor. Mr. Reynolds is definitely unopposed to no contacting and stay away from Ms. Daquania. Sorry if I mispronounced that. Ms. Daquania Ellison.
On the battery substantial physical harm, it's going to be a $2,500 surety bond. On the cruelty in the third degree, that's going to be a $1,000 signature bond through the jail. That's a $3,500 split bond. No further contact with Miss, and I do apologize, Daquania Ellison. And to stay away, I believe this is at 514 Park Valley Drive. I'm not sure the location.
Your Honor, the location of the incident,
Oh, was it 15 Mount Zion?
yes, Your Honor.
Okay, and to stay away from 15 Mount Zion in Atlanta, Georgia, that entire complex. No alcohol, drugs, and weapons. And your next court date will be December 1st for the misdemeanor case.
All right, we're gonna go past this one too. Let's see what else. All right, this guy here, right? This old fella here. 3 guesses what his charge is, y'all. 3 guesses. Do you think it's battery or criminal trespass? Which one is it?
Anthony Montgomery is accused of criminal trespass from November 11, 2022 in 22 CR 007739G.
If you guessed criminal trespass, you'd be right. You would be right. But we continue. Fair use, Negroes, fair use.
Mr. Montgomery, you've been advised of your right to remain silent, and your attorney is Ms. Thomas. Ms. Harrison, how many cycles, please?
27 cycles with one arrest out of Kansas. Last arrest was September of this year for criminal trespass.
Another criminal trespass in September.
In Atlanta, Georgia. That is an open case, 22 CR 006603G.
Thank you. That's good. Ms. Salette?
Yes, Your Honor. As stated, the defendant is out on a signature bond for criminal trespass from September of this year. He also has a 2019 conviction for criminal trespass and 3 criminal trespass convictions from last year, 2021.
Man, this dude is a repetitive criminal trespasser. He just continues to criminal trespass. He's a serial criminal trespasser. But we continue.
The state's recommendation at this time is $1,000 surety bond. Stay away from the incident location, which is MARTA station at 216 Peachtree Street.
But even with that, the Solicitor General is asking for $1,000 surety bond. That means $100. He walks out the door. All right, because like I said, criminal trespass isn't that big a deal, even though this dude is a serial criminal trespasser, as you just heard. The Solicitor General is like, $1,000, $100, he's out the door. And when you see these people with these multiple criminal trespasses on their record, the meat and potatoes of that is these dudes are usually homeless, all right? They sleeping in train stations, they sleeping in train cars, they sleeping in warehouses, they sleeping in they sleeping in storage units. These are homeless people who keep finding themselves in these places, and people are calling the police on them because, see, what I believe the criminal trespass is, first you have to be trespassed off of a place, basically told to leave, all right? Because I don't believe you can just be arrested on criminal trespass the first time you're there. You have to be legally trespassed by someone who owns the property or someone who's responsible for the property. They say, look, I want to trespass this guy. I don't want him here no more. And they don't usually arrest the person right then and there. The person gets arrested if they come back after being trespassed. Now they have criminally trespassed because they've been told not to come back there, told not to sleep there, told not to be pissing on the side of the building, told not to be on the bench drunk, but they're back. So now it's criminal trespass, and now you are subject to arrest. But we continue.
And no alcohol, drugs, or weapons while out on bond.
Ms. Thomas?
Thank you, Your Honor. I would be asking for a signature bond or a bond no more than 500. Mr. Montgomery is residentially challenged.
Residentially challenged, AKA homeless. But we continue.
He has been for quite some time. I know our office has worked with Mr. Montgomery on a few occasions and has assisted him with getting into some shelters as well. I believe, like most, Mr. Montgomery frequents MARTA, obviously for warmth or shelter. But Your Honor, given that this is a nonviolent offense, and I don't believe there's any mention as to why Mr. Montgomery was asked to leave the MARTA station. I believe Mr. Montgomery would be a good candidate for a signature bond, but as I mentioned, Mr. Montgomery is residentially challenged. He is unemployed, so essentially any bond would be no bond for him. So if the court is not inclined for a signature bond, I would be asking for a bond no more than $500. Again, Mr. Montgomery is 59 years of age. He has been a long-term Georgia resident. I remember that Mr. Montgomery does have a sister residing in Georgia. I would have to find her contact information, but I have spoken with her on occasion before, Your Honor.
All right. Bond's going to be set at 1,000. It is a surety bond. And we're going to reset this case as well as the other open case, 22 CR 006683G. And both cases are going to be reset to December 1st for plea and arraignment on that date.
Yes, plea and arraignment, and they probably what the Solicitor General is probably going to do with this case, because he's coming back in December, which will be another month from now. They're probably just going to let him out. Yeah, they're just going to let him out. Keeping him in jail is probably doing him a damn favor. He has nowhere to live, right? 3 hots and a cot is probably doing him a favor. Yes, these people with these multiple criminal trespasses, when the judge locked them up, they're doing them a damn favor. They're making sure they eat, making sure they got a place to sleep, a place to shit, shower, and shave. They can watch some television, they can lay around, clean clothes, all of that. So he should be happy. He don't got to sleep at the damn train station, at least for the next month. Because in another month, they're going to evict his ass out of the jail because, what? They're going to let him out. They're going to let him out. So he's going to get evicted from the jail in another month. But we continue.
To stay away from the model location at 216 Peachtree Street. Thank you.
Thank you.
Well, okay, Montgomery, come on. Come on. You got a good bond. You got a good bond. You got a good bond. Dang.
You see the did you see the CO? Did you see what the CO did? Did y'all catch that? Let's see if we can catch it. Look at what the CO did after he got up.
Peachtree Street. Thank you.
Thank you.
Okay, Montgomery, come on. Come on. You got a good bond. You got a good bond.
You see what the CO's doing? He's spraying, I don't know, it could be Lysol, I don't know, but he's spraying something. And that's the first time I've seen that CO do that today. The first time I think I've seen that CO do that ever. Because he's probably in there smelling like all kind of cesspool and mildew and whatever. And the CO has 2 cans, not 1, but 2. But we continue. Fair use, Negroes. Fair use.
You got a good bond. Dang. Well, when you get out, I'll talk to you later. Next, we got position number 1, Mr. Bailey.
Mr. Kenneth Bailey II is accusation number 22 CR 0077418. Mr. Bailey, not sure what happened on December 22nd, 2021, but there are 6 traffic-related charges brought against you. They begin with seatbelt violation as an adult, fleeing or attempting to elude an officer.
All right, we're going to zoom past this one because this one is foreign to us. Let's listen. Fair use, Negroes. Fair use.
Ms. Anderson, do we have a, I guess we have a cross-defendant. I see Ms. McLeod on this case.
Yes, Your Honor.
Okay. So Mr. Reese Davis is 22 CR 007746B. Mr. Davis was accused of simple assault, domestic violence from November 10th, 2022. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod.
And notice a lot of these cases that these brothers come in, except for the dude that, they had to spray Lysol after he got up. A lot of these dudes, they come in for battery and assault. Now, assault, battery are somewhat similar, right? When you talk about battery is a person commits an offense when he or she intentionally causes substantial physical harm or visible bodily harm. I believe assault is similar, but it's a little bit different. As a matter of fact, let me go ahead and pull that up right fast. Should have had it already up. God damn it. Go ahead and pull that up. I want to get this right. I know they're similar though. I know they are similar. Now assault, according to this, assault is defined as when an individual acts in a way that makes another person reasonably frightened that they will be violently harmed. But battery is somewhat similar, right? Like we said, a person commits the offense of battery when he or she intentionally causes substantial physical harm or visible bodily harm to another. So it's kind of dicey with the language, but they're pretty similar. I guess it all depends on, what you did and what the condition of the person is you did it to, and what their statement is about what you did. I guess that's what dictates whether or not they charge you with battery or charge you with assault. But those two charges are pretty similar in nature. But we continue. Fair use, Negroes. Fair use.
Any priors, Ms. Harrison?
No prior, Judge.
All right. And Ms. Anderson?
Your Honor, the state is seeking a $3,000 surety bond.
Notice it's always $3,000. That's where they go first. Even if you notice, you heard the brother don't have any priors, right? None whatsoever. No priors. $3,000 right off the rip.
In this case, a stay away from 2070 Cheshire Bridge Road Northeast. The specific apartment is 408, though we are asking for a stay away from the entire complex. No contact with the victim, Tiffany Thornton, common spelling, no alcohol, drugs, or weapons, and a one-day anger awareness class. And just for the record, Your Honor, the state has reached out to the DA's office to see if they want to receive this case so that both of the cases can travel together.
Okay.
No response yet, though.
All right. Ms. McLeod, does your client own or lease that particular location at 408? I can't remember.
It's leased, Your Honor.
To both of them?
Yes, Your Honor. That's my understanding.
Now, you heard what he said. You heard what the public defender said. That place is leased to both people, right? To both people. And they said it's, I think he said it was a cross defendant. Therefore, what you're talking about is two people who got arrested on the same day, probably for the same crime, right? I think that's what that means. He got arrested, she got arrested. But we continue.
But he does tell me that he does not have to stay there. He can stay with his mom.
That makes it easier.
Now see, he going back to his old mama house. He's got to leave his house. Criminally evicted from your own house because you got into a scrap with somebody at your own house. So now you cannot go back to your own house.
Bond is going to be set at $3,500. It's a signature bond through pretrial services. Mr. Reese, you can be released on a signature bond through pretrial. You'll have to report to pretrial once a month. You are to have no further contact with Tiffany Thornton, and you are not to return to the 408 location. If you have if he has personal belongings there, he may return one time only with a police officer to retrieve his personal belongings.
From his own house. He's only allowed to go there one time with the police officer to retrieve his personal belongings. But we continue.
But that visit cannot exceed 1 hour.
And you can only be there for an hour. Let's not leave that out.
Stay away from Ms. Thornton, not communicate with her in person, through a third party, through a phone, computer, or even on social media. Thank you. Oh, and your next court date, this is important. Within 30 days of being released, you must update us with your new address so that we can send you notice of your next court date. Because if you don't show up, we will have to issue a warrant for your arrest.
Mr. Reese Davis?
Do you have a question about your address?
Or about going back to the house?
No, I was gonna say that the address on my driver's license, 8188 Mackenzie Place, that is, that's the address for me. So, I don't have to worry about that.
That's a good address. Okay.
That's for me. And I was just gonna ask if you could just repeat the conditions again.
No further contact with Tiffany Thornton. Do not contact her in person, through a third party, through a computer, cell phone, or even on social media.
Understood.
You're not to contact her definitely not in person. You are to stay 200 yards away from the 408 address, and you can go there one time only with a police officer to retrieve your personal belongings. That visit cannot exceed 1 hour.
Understood.
And we do have a Mackenzie Place address, so we will send your notice to that location. Thank you.
Thank you.
Who's that bond amount, Your Honor?
3,500 signature bond through pretrial.
Thank you.
Your Honor, that concludes my business before the court today. May I be excused?
Now he gonna sign and he out of there. His first arrest. Usually when it's your first arrest, this judge is gonna let you out. She's gonna let you sign and roll. That's one thing I can say about this particular judge. This judge is hard, but she is fair. I'll say that again. If it's your first arrest, more than likely you're gonna sign and you're out of there. All right? But don't mess around and not come back to court or get locked up again. Because if you do that, she's gonna hammer your ass. But we continue.
Yes, Ms. McLeod, you have a great weekend. Thank you.
Thank you. You too, Judge.
Next, we have position number 7, Jawan Johnson.
I'm trying to remember if I even watched this much of this, because believe it or not, y'all, I didn't even watch this whole thing. I just watched the other stuff. Well, let's go. Fair use, Negroes. Fair use.
Mr. Jawan Johnson is accused of battery, domestic violence.
Battery, domestic violence again. Battery. Criminal trespass is the theme of today. Battery, criminal trespass is the theme of the day. But we continue. Fair use, Negroes. Fair use.
In case 22 CR 007737B from November 11th, 2022. Mr. Johnson, you've been advised of your right to remain silent, and your attorney is going to be Ms. Thomas. Ms. Thomas, this is a confirmed representation?
No, Your Honor. Unfortunately, Mr. Johnson is overqualified currently.
Yep, he don't qualify. What that means is this dude got a job. He's employed. He's got a job. He makes a decent amount of money. So the public defender can't even represent him. Because to be represented by the public defender's office, you usually have to be unemployed or underemployed. When people come in here and the public defender says they can't represent them, it's usually because they make too much money, right? They got a decent job, they make a good wage, so public defender is not going to represent your ass except for this first appearance, this arraignment. After that, you're on your own. You got to get your own damn lawyer. But we continue. Fair use, Negroes. Fair use.
All right. Mr. Johnson, the public defender's office can represent you for the bond hearing today. But after today, you will have to retain your own counsel, or you would have to represent yourself, keeping in mind that you are responsible for all legal decisions. Understood?
Understood.
All right. Mr. Johnson's been accused of battery domestic violence against one Jasmine Johnson. Ms. Harrison, any priors?
Second arrest, Judge. First arrest was June of 2019 for possession of marijuana less than an ounce in Clayton County. He completed PTI and that charge was dismissed.
Okay.
So he's probably going to get a signature bond. He doesn't have a lengthy criminal history. He's probably going to get a signature bond from this judge. But let's see. We continue.
Thank you. Ms. Saleh?
Yes, Your Honor. Due to the victim being his sister, they do live in the same household. The state is requesting a $5,000 surety bond. No alcohol, drugs, or...
Wow, now that's rare. 5,000 she's asking for. And this is Mrs. Badass Scream, Solicitor General. But we continue. Fair use, Negroes, fair use.
Weapons while out on bond. No contact with Jasmine Johnson. Stay away from the 4881 Brookwood Place. That was the incident location. Nothing further at this time, Your Honor.
Thank you. And Ms. Thomas?
Yes, Your Honor.
Any argument for bond?
Oh, I'm sorry. I thought you were about to ask me a question. Sorry, Your Honor. Yes, Your Honor, I would be asking for a signature bond on Mr. Johnson's behalf. He is denying these allegations as being the primary aggressor. We are also asking that he be allowed to return back to his home. That is his mother's home. I also spoke with Ms. Chantel Johnson, which is his mother, and she did express to me that not only her, the grandmother that was also at the residence, and another sibling tried to explain to law enforcement that this was a sibling fight, and that what the complaining witness.
Okay, now y'all listening to what the public defender is saying, right? Now, they got into some type of confrontation at the house, right? Because you know these old grown-ass 30-year-old motherfuckers still living with their mom and shit, right? So they got into a fight at mom's house. Right? Now, the person he got into a fight with lives in the house. I believe they said it was one of his siblings. So guess what? He's going to get criminally evicted out of that house. The judge is going to tell him he cannot return to that house. That's what she's going to say. Y'all know that, right? Once the public defender start explaining the situation, where the confrontation took place, and now that the judge is aware of the fact that the person he got into the confrontation with lives at the house too, even though he lives there, he will not be allowed to go back there. Criminally evicted. Remember, it's the theme. Criminal trespass, criminally evicted. But we continue. Fair use, Negroes. Fair use.
Told the authorities was not accurate, that they want Mr. Johnson to come home. Obviously, the law enforcement officer told them that since the complaining witness called the authorities that someone had to be taken into custody. I believe she left the location. It's my understanding that she left the location at the time. So Mr. Johnson was the only one that was arrested. Again, Mr. Johnson is 25 years of age. He has been a Georgia resident all of his life. He completed high school and he has attended some college. He is gainfully employed. He works at FedEx. He's been working there for the past 3 months. He currently doesn't have any children. And Your Honor, as we heard, he doesn't have any significant criminal history, specifically no violent history. So I am asking for a signature bond. I believe he was also recommended, asking for no further violent contact with his sister.
Now, he is going to get that signature bond. He's going to get that because he doesn't have a lengthy criminal history. This judge here is going to let him sign and walk. But he's getting criminally evicted now. That's happening. But we continue. Fair use, Negroes. Fair use.
And that he be allowed to return back to his mother's residence in which he stays. Because further, Mr. Johnson did express that he does not have anywhere else he would be able to go.
Well, he's going to have to find some place to go.
You heard what the judge said. What did I tell y'all? The judge said, well, he gonna have to find somewhere to go. Because like I said, you have now been criminally evicted from your residence. But we continue.
Bond is set at $3,500. That's going to be a signature bond through pretrial services.
Yep, she gonna let him sign and walk now. Yeah, you gonna get out of here today. But you better not go back to that damn house, though. But we continue.
No further contact with Jasmine Johnson, and he will not return to 4881 Brookwood Place in South Fulton. He may return to that location one time only with a police officer.
And the visit cannot be more than an hour, Negro.
To either retrieve his belongings, a visit that cannot exceed 1 hour, or to verify that Jasmine Johnson has vacated the premises and does not live there. If she does not live there, he may return to that location. But if she's still living there, he cannot share the same home with her. Within 30 days of being released on pretrial bond, he must report every month. He must report every month, but within 30 days of being released, he must update us with his new address so we can send him his new court date. He will report to pretrial once a month. And while he is out on a pretrial bond, he will complete an 8-week anger management program at his expense. Those classes must begin within 60 days of being released. Thank you. No alcohol, no drugs, and no weapons and no firearms.
Thank you.
You see that hand, right? Whenever you see them raise that hand up, they about to say something that not only isn't going to have any bearing on what's happening here, but usually has nothing to do with what's happening here. You're getting out. Shut your ass up. Go sign your name and leave. What else is there to discuss at this point? The judge is letting your black ass out. Go sign your name and shut your ass up. But black folks, we just can't do that, can we? We must talk. Even when things go our way, we still must talk. Negro, you're getting out. Shut up. But we continue. Fair use, Negroes. Fair use.
Yes, Mr. Johnson, do you have a question about your bond?
No, I have a question about the resident. So if I can't be able to go to my mother's house back, or
if you can't do what?
If I'm not able to go back to my mother's house, what else can I? What's up?
You are 25 years old and fully employed.
You hear what the judge said, right? You're a grown-ass motherfucker. I shouldn't have to tell you this. You're an adult. Why are you even asking me this? It's like these people are, it's almost as if they're like challenged, right? Because why do you have to ask the judge this? Especially this judge. Because this judge is going to tell you like it is. This judge is going to say, like she said many occasions, look, you're an adult. You shouldn't even be asking me this as an adult. But like I said, Negroes must talk, even though she's letting your ass out of jail. Go sign your name. Shut your ass up. Figure it out when you get out of there. You're getting out. Shut up. Dumb Negroes. But we continue. Fair use.
I guess you'll have to find someplace else.
And Mr. Johnson, I spoke with your mom. I'm going to update her as well. She told me to give her a call back, so she'll be able to assist you.
And why should she have to? Why should she have to at this point? I say again, he's getting out for free. Just sign your name and walk out the jail and shut your mouth, Negro. See, these are the products of the baby mamas. Grown-ass motherfuckers. Even when shit goes their way, they don't know enough to keep their fucking mouth shut. They just don't. Because guess what? Every goddamn woman around them has to be their damn mama. It's stupid. But we continue. Fair use, Negroes. Fair use.
Okay. All right. Up next, Your Honor, we have position number 8, Mr. Brock Mills.
Brock Michael Mills is case 22 CR 0077408, accused of battery domestic violence from November 11, 2022.
Another battery. I told y'all. Battery, criminal trespass. That's all what you've seen. Criminal trespass, battery. Criminal trespass, battery. Battery, criminal trespass. That's all you see. And every single one of these batteries that you see is a quote-unquote domestic, right? Every dude you've seen come through here is some damn battery against some broad. Like, and this is just one of many of the court cases that I've looked at, right? That I've watched. But usually, this is how it goes in this courtroom. Batteries, criminal trespass. We continue. Fair use, Negroes. Fair use.
This is with regards to was it a Candace Paulson? Or Candace Paul?
Candace Paul, Your Honor.
Okay. Just want to be sure I got my notes right. Okay. Mr. Mills, you've been advised of your right to remain silent, and your attorney is going to be Ms. Thomas. Ms. Thomas, will he have to retain his own attorney, or will the PDs represent him?
Yes, Your Honor, he'll have to retain his own attorney. He is overqualified.
All right. Ms. Harrison, any priors?
9 cycles with history in Nevada and California. Last arrest, October of 2011, battery in Las Vegas, Nevada. No disposition listed on that arrest. Record indicates 3 misdemeanor conviction outside the 10-year period in California. Nothing further.
All right. Ms. Saleh?
Yes, Your Honor. I did not see any violent arrests in his history. I did see a 1999 disorderly conduct involving alcohol conviction, 1997 DUI conviction, and 2004 DUI conviction. And the victim did allege that there was alcohol involved in this incident as well. The state's recommendation at this time is going to be a $5,000 surety bond. no alcohol, drugs, or weapons while out on bond, no contact with the victim, Candace Paul, and that's Candace spelled with a K.
Okay. Ms. Thomas?
Thank you, Your Honor. We will be requesting a signature bond or a bond no more than $1,000. Mr. Mills is 44 years of age. He and his family moved to Georgia a year ago. They bought a home here. He's originally from California. Mr. Mills did express that he's also the primary breadwinner of his household. Mr. Mills is currently employed at the Altitude Aviation Group. He's been a manager of sales there since 2017. He's also the proud father of 3 children. He has 5-year-old twins and a 2-year-old in which he and Ms. Paul do homeschool the children together. When I spoke to Mr. Mills, and I don't believe that I heard any prior violent history. When I spoke to Mr. Mills, he also expressed the same. Would be asking for the signature bonds or the bond no more than $1,000. Mr. Mills did express that he would like to be able to return back to the home. However, he is not financially incapable of finding somewhere else to stay until.
Oh, if the incident took place at over there, this judge is going to tell him not to go back there. That's what's going to happen. Now, he has a little bit of a history, so she might want him to pay a surety bond. But as y'all heard, the white man got a pretty good job, so it's not going to be that much. His bond is probably not going to be no more than maybe $3,000. So $300 he's walking out of there. But we continue. Fair use, Negroes. Fair use.
This case is resolved. We're also asking for no further violent contact with Miss Paul since they do share those 3 children.
Any word from Ms. Paul?
I did not have her contact information, Your Honor.
Ms. Salette, it's difficult at this time. Yes,
Ms. Calloway, do you recall if you were able to make contact with Ms. Paul?
No, I didn't have a good contact number for her. And I think
This person here down at the bottom right-hand corner has been here the whole time. I believe she is the victim's advocate. I think she speaks on behalf of the victims, the victims of the batteries and the assaults or whatever, because every now and then you see people pop up on the screen as the victim, but you didn't see that today. And she's been relatively quiet, so that means her black ass ain't spoke to nobody today, because this is the first time we've heard her speak the whole time. So she hasn't got in contact with anybody. In other words, she hasn't done her damn job. But we continue. Fair use, Negroes. Fair use.
I believe I called her, but it was no return call back from her.
Thank you, Ms. Calloway. So yes, Your Honor, we have not had contact with the victim, so we would reiterate our request for no contact, and we would be unopposed to third-party contact for the children that they share.
Now, why would she be opposed to third-party contact with the children? That I don't understand, but we continue.
Bond is going to be set at $3,500. It is a signature bond through pretrial services.
Uh-oh, the white man gets a signature bond too. Sign and you're out, white man. Sign and you're out.
No further contact with Candace Paul until further order of the court. And to Mr. Mills, you are not to return to 744 Towns Creek Drive in Canton, Georgia. You would have to find alternative housing until further order of the court. You are to update the court with your new address within 30 days of being released. You're not to contact Ms. Paul in person through cell phone, computer, or any kind of, or through a third party or any kind of computer device. You may contact a third party in order to arrange third party transfer of the children if both of you and Ms. Paul decide to share visitation while this case is still open and pending. But until another order is issued, you cannot return to that location or have any contact with Ms. Paul. You may return one time only to the Town Creek location in order to retrieve your personal belongings.
You see, even the white man gets what? Criminally evicted. But we continue. Fair use, Negroes. Fair use.
You may do so in the company of a police officer. So Canton, Georgia, that's what, Cherokee County?
Correct.
Right. You will have to go to a precinct out in Cherokee County and let them know that you have no further contact and that they need to accompany you to the home to retrieve your belongings. Don't forget to report to Fulton County pretrial once a month. And while you are out on a signature bond, you will complete an 8-week anger management program at your expense. That classes must begin within 60 days of being released. Thank you.
Thank you.
Notice how the white man sat there and didn't say a word. Nothing. And he was told the same thing all the rest of these people was told. Don't go back to the crib. Your ass is criminally evicted. No alcohol, drugs, or weapons while you're out on bond, etc., etc. You want to see your kids, you got to have a third party person come in. You know, that's how you can get to see your kids through a third party. The white man didn't say a word the whole time. Why? Because he realizes he's getting out. There's nothing to say. Why blurt out some old foolishness just to be doing it? The white man didn't say a word the whole time. Why? Because he understands shutting up is better. But we continue. Fair use, Negroes. Fair use.
And next we have position number 10, Mr. Jason Pierce.
Oh boy. Now, I'm going to tell y'all something about these dudes with dreads and the dyed tips. Now, I have dreads myself, but I don't dye the freaking tips. You see these Negroes with these dreads and these dyed tips, they're usually degenerate savages, and they're usually low IQ too. Now this part I didn't watch, but I'm just making an assumption that you're probably about to hear some of the most stupid stuff you've ever heard in your life up until this point. And I guarantee you that he is going to get up here, blurt out all kinds of ridiculousness that doesn't need to be said. Even if he gets out, he's not going to have the wherewithal to just shut up, go sign his name, and walk out the door. Nope. Fair use, Negroes. Fair use.
Want to say something?
I'm trying to make sure I don't mispronounce. Is it Jason Taylor Pierce?
You have it right.
Thank you. 22 CR 0077388. Mr. Pierce is accused of criminal trespass from November 10th, 2022.
Criminal trespass again. When we continue.
Mr. Pierce, you've been advised of your right to remain silent, and your attorney is going to be Ms. Thomas. Ms. Thomas, will the Public Defender's Office continue to represent him?
Yes, Your Honor, he qualifies.
All right, thank you. Ms. Harrison, any priors, please?
6 cycles, last arrest, March of 2015 for criminal trespass in Sandy Springs, Georgia. That arrest was amended to non-fingerprintable charge. A 2010 misdemeanor conviction for carrying concealed weapon in DeKalb County. Nothing further, Judge.
Well, he don't have a long, lengthy record, but this is his second criminal trespass. And you remember what I said about these serial criminal trespassers. They have a tendency to just always be somewhere where they're not supposed to be after being told to leave, because that's usually how the criminal trespass statute works. You are told to leave. The cops are called. They trespass you. The cops escort you off the premises. You return. When you return, that is when it is now criminal trespass, and now you are up for an arrest, because you can't be arrested for criminal trespass unless you've been trespassed off the property prior to that. So basically, these Negroes go somewhere, the cops are called, they're told by the police to never come back, and what do? They say, you know what? I know what I'm going to do. I'm going to go back to the place where the police told me never to come back to. But we continue. Fair use, Negroes. Fair use.
And Ms. Saleh?
Yes, Your Honor. The state's requested.
Because look, just look. Look at him. He's not even looking at the screen. He's got his hair in front of his damn face like one of them shaggy dogs. He's not even looking at the screen. He's not paying attention to what his lawyer's talking about. He's not looking at the judge. He's not looking in the camera. He literally has his hair in front of his face like it's a damn mask. UMI, undiagnosed mental illness. But we continue.
At this time, due to him having a previous criminal trespass conviction, is $1,000 surety bond. Stay away from the incident location, and that's at 11715 Medlock Bridge Road in Johns Creek. And no alcohol, drugs, or weapons while out on bond.
Judge, the only criminal trespass I'm showing is in 2007 for DeKalb. It was a no-low. I'm sorry, it's a no pros.
Oh, okay. I thought you mentioned a 2015.
No, 2000. That was amended to a non-fingerprintable charge.
Okay. Yeah, I got that. All right.
That's correct.
And would that amend the state's position?
No, Your Honor. Let me look at our copy of the GCIC really quickly. Okay, I see, Your Honor. Our there was a criminal trespass that was reduced to disorderly conduct. That was a guilty conviction. So it started out as criminal trespass, but it was disorderly conduct. My apologies. But in this case in particular, the defendant was criminally trespassed on November 2nd and was right back at the same location about a week later.
See, he was trespassed right back a week later. I mean, I don't even know how a person with average intelligence gets a criminal trespass charge. Because you go somewhere, they call the police tell you, don't come back here. They escort you off. Why the hell are you back? What are you back for? I mean, one thing I don't understand about many Negroes, right? Negroes always want to be somewhere where they claim they never wanted to be in the first place. And they always want to be somewhere where they know they're not wanted. I don't get it. You know these people don't want you there because they called the police and had you escorted from there. So what do? You turn around and you come back tomorrow? You come back 5 days later? What the hell did you think was going to happen after the police done already wrote up a report on your black ass and told you not to come back here? Like I said, oh, the police told me not to come back. I know what I'll do. I'll go back tomorrow. Oh, man. tell you. Fair use, Negroes, fair use.
And also admitted to officers that he knew that he wasn't supposed to be there.
Told the police that he knew he wasn't supposed to be there. But there he was. There anyway. He didn't even have the wherewithal to say, well, you know, I didn't know I wasn't supposed to come back, officer. No, he told the police that he knew he wasn't supposed to be there. I know while he was telling the police this, they probably was standing there like, looking at him like, are you serious right now, man? Are you serious right now? We continue.
Nothing further from the state.
All right. Ms. Thomas?
Thank you, Your Honor. We're requesting a signature bond. Mr. Pierce is 32 years of age. He's
32 doing this shit. This is a 32-year-old person being told to leave somewhere by the police, getting escorted off the goddamn property, but turning right around and bringing his black ass right back there the following week. For what? What there is so great that you risk arrest to be there? What's there? Are you digging for gold there? Is there a money tree there? What's there? Is some hole there that you're trying to get at? I mean, what? You know if you go back there, you're getting locked up. But you go anyway. We continue.
a Georgia resident. He did complete his GED. He doesn't have a significant criminal history. Your Honor, we're asking the court to consider that. I did speak to Mr. Pierce. He did express that he does understand and is not opposed by staying away from the Panera Bread location.
Bullshit. He doesn't understand. He doesn't. Because if he understood, he wouldn't have had his black ass there. He wouldn't have been there if he understood. But we continue.
He stated that this was a complete misunderstanding and that he did have permission to charge his phone from an employee at the establishment.
Are you hearing this? He knew he wasn't supposed to be there, but he said an employee at the place told him he could charge his phone in there. Now, why didn't he just go to, like, I don't know, a library or a train station or something like that? I mean, there's parks you can go to where there's outlets for you to charge your phone. Starbucks, anywhere. No, a place where he's already been trespassed. He goes to an employee that works there. Notice they said an employee, because if he got trespassed, it probably was by like the manager or the supervisor or somebody, right? So one of the employees at a place that he's been trespassed from tells him he can charge his phone there, and he goes in there and charges his phone even though he knows his black ass ain't supposed to be in there. That doesn't even make any sense. Why would you be anywhere near it? Oh man, I know I ain't supposed to be here, but you think I can just come in and charge my phone? Now, you heard what they said, right? He's 32, not 12, 32. But he goes somewhere where he knows he's not supposed to be to charge his phone. Now, let me ask you good folks something. Who do you think raised this Negro? Just listen to how he thinks. Who do you think raised this Negro? But we continue. Fair use, Negroes. Fair use.
But again, that he has no problem understanding that he is not to return back to that location. Mr. Pierce also expressed that he is currently unemployed. However, he was able to secure an interview and orientation at McDonald's, which is supposed to start on Monday. So he does wish to be able to attend orientation so that he can gain the. I'm sorry, Yana.
Which McDonald's?
Mr. Pierce, do you have the McDonald's location?
I know exactly where this Panera Bread is, so I need to know which McDonald's.
I'm telling you right now, it's right there on it's not far from the Panera. It's down the street from it.
What is it next to?
It's next to a synonymous bank.
Okay. Anything else, Ms. Thomas?
I don't have to work there.
Nothing further.
I don't work there.
You keep talking, Mr. Pierce. You're talking into a cash bond.
You heard that? The judge is like, if you keep talking, you're going to talk your ass right on into a cash bond and be in jail, you stupid idiot. In other words, she's telling him she's going to let you out. Shut your ass up. Shut up. She's telling you, you keep talking, you're going to talk yourself into a cash bond. In other words, I'm letting your dumb ass out. Shut your ass up. See, me, I couldn't be no judge. I couldn't be a judge. I'd be like, Negro, I'm letting you out. Shut your ass up. But we continue.
Mr. Pierce, please remain silent. Nothing further, Your Honor.
Notice his lawyer's like, shut your ass up. The judge gonna let you out. Shut your dumb ass up. You said enough with your stupid freaking dyed tip dreads that you got in front of your face like some damn shaggy dog, you ridiculous Negro. Look at the look on all the people's faces. Look at her. Look at her. I don't know if y'all can see my pointer, but look at the look on the court reporter's face here in the right. Look at the look on her face. The damn Solicitor General is like, has got her eyes closed like, these Negroes are idiots. And even his lawyer's like, just shut your ass up, man. The judge's about to let you out. Be quiet. We continue.
Thank you. His bond is going to be set at $3,000. It's going to be a signature bond through pretrial services.
And see, even with all of that, the judge is letting his ass out. Sign and leave. No talking.
And if he gets arrested again for anything else, whether it's trespass, disorderly conduct, jaywalking, I don't care, spitting on the sidewalk.
She's had enough of this Negro. He said if he's arrested for anything else, even spitting on the sidewalk.
If he gets arrested for anything else and he's back in the Fulton County Jail, this signature bond will convert to a good bond or a cash bond only. Mr. Pierce is to stay 200 yards away from the Panera location at 11715 Medlock Bridge Road. And if he is anywhere near that Panera, on the sidewalk, in the parking lot, anywhere near that location, the authorities are able to arrest him and his signature bond will be revoked. So, Mr. Pierce, you are on notice right now that you are not to return to that Panera. And if that means taking the long way around to get to McDonald's, that's what you'll have to do. You cannot be on the parking lot, the sidewalks, or anywhere inside. I don't care who gives you permission to come in there, you are not allowed into that restaurant. Do you understand?
Yes, say so.
Yes.
Good. His next.
Now, when he needed to be saying something, he's not saying anything. The CO got to tell him, oh, you got to answer. He's running his old dumb mouth the whole time But when the judge want him to say something, he ain't saying anything. Boy, I tell you, we continue.
Next court date is going to be sent to him at his address, and I have a Duluth address.
Yes, Your Honor. 16.
Centerview Drive.
Yes, Your Honor. That's correct.
Okay. His next court date is going to be sent there. He will have to report to pretrial services once a month. Like I said, if he fails to report, if he gets arrested again, he'll have to come back to jail with $3,000 in his pocket. Thank you.
Thank you, Your Honor.
That's all we have there. Your Honor, I believe we finished with the calendar.
Now, that's it, right? That's the last case, right? This dude here. And, you know, y'all saw quite a few cases, you know, throughout this, I don't know, I guess, hour and 30 minutes it's been quite a bit. But y'all see what most of the cases are. Criminal trespass, battery. Criminal trespass, battery. And the batteries are the ones that will get your ass criminally evicted, right? They will get you criminally evicted. Depending on where the quote-unquote battery took place, even if it's your house, you own it, you lease it. If you get charged with it, and you had that confrontation with somebody that lives there, even though it's your house, you're not allowed to go back there. Now, I know a lot of these people do still go back there because, you know, Negroes is hard-headed. Now, you may say, oh, well, you know, it's their house. It doesn't matter that it's your house. Your ass been ordered by a judge to not go back there. So, you go back there, your ass subject to arrest. But it's the same thing with the criminal trespass, ironically, right? You're told to leave. They trespass you officially on paper. You're told not to go back there. Do not come back there. But what do Negroes do? They turn around and they come back. It's crazy how these charges that you've seen here today, man, are they're kind of intertwined, even though they're two separate charges, but they're kind of sync up a bit, right? Because I say again, criminal trespass, you somewhere where you've been told not to be. With the battery, you get out of jail, you're told not to be somewhere. So what happens if you go back after you've been arrested for battery, told not to go back to your house? When you go back there, are you charged with criminal trespass, or are you just jammed on violating your bond conditions? Is going back there criminal trespassing? Now, of course, you haven't been told by anyone on the property not to come back there, but the judge has ordered you not to come back there. It's weird. How does that work? And how much you want to bet? Some of these Negroes, these criminal trespassers, guess what? They'll be right back here again, because they're going to go right back to a place where they've been told not to go, not only by the people who own the property, but by this judge. And how much you want to bet that some of these people who've been told not to go back to these residences will be right back here, because they've been told by this judge to not go back there. Because like I said, and I'll say again, Negroes have a tendency to be places where they know they're not supposed to be. That's what you saw today. And a lot of these people who were told not to go back will go back anyway. Criminally trespassed. Criminally evicted. But that's all. I appreciate everybody coming through, man, and spending this hour and some change here, man. You could have spent your time anywhere. You decided to spend it here. It is appreciated. I don't take good folks lightly, man. I never have and I never will. You got my word on that. So, with that, I will leave you good folk with 3 words. You know, like I always do. Open your mind. Peace, folk. X with another.
The darkness continues.
Only from T.P.O.T. Media. Open your minds.